Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. So, we received an interesting inquiry here on our YouTube channel. This has to do with somebody who got accused of a robbery. Let's see here. My 22-year-old nephew assaulted and hit an elderly person in order to steal his backpack. My nephew, years ago, was arrested for vandalism. Well, yeah, okay, well, flat out, it says right here that it was your nephew, and, yeah. So this is a robbery, flat out. This is a robbery. This is a violation of Penal Code Section 212.5 here in the state of California. Obviously a felony that carries up to 6 years state prison and is also a strike, which makes it a mandatory prison sentence. Now, here's the thing. Robbery is the taking of the personal property of another with the intent to permanently deprive that possessor of the property using force or fear. In this case, he used force. Now, if the victim got hurt, there could be additional charges based on grave bodily injury, which would dramatically increase the punishment that your son would face. At this point, though, he would be facing up to 6 years in state prison. Now, it says right here that he has a previous vandalism case. Well, I would need to know how old that vandalism case is, and I need to know if the vandalism was a misdemeanor or a felony. It makes a huge difference. If the vandalism is more than 10 years old, it's not going to be considered priorable. It's not a priorable offense. If it's less than 10 years old, it is definitely a priorable offense, which means that they will use it to give your nephew additional punishment for the new case. And of course, vandalism is something that can be charged as a misdemeanor or a felony under the same code, Penal Code Section 594 here in the state of California. It can be charged as a misdemeanor if the amount of damage caused is less than $950. If it's $950 or more, it's going to be a felony that carries up to 3 years state prison. So you can see how, seeing that he may have been charged with a felony here, and then, 5 years later, now we have a new felony, in this case, a strike, that's definitely going to raise an eyebrow. It's going to show that he has very little regard for the law. Now that he's being charged with a strike, he needs to be extremely careful, because if he is in fact convicted of this strike, and if he goes to prison, any other felony that he commits in the future will result in additional prison time. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. But if you've been accused of a crime and need representation in court, call us now for a free consultation at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who was driving under the influence of alcohol and drugs. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyer, criminal attorney, criminal attorneys, DUI attorney, DUI attorneys.